What are the international human rights responsibilities of corporations? Have you ever wondered what responsibilities corporations have when it comes to international human rights? This topic is becoming increasingly important in today's globalized world. Corporations are expected to respect internationally recognized human rights, and this responsibility is distinct from the obligations of states. It applies no matter what the local laws say in the countries where these companies operate. So, what does this mean in practice? First off, corporations should avoid violating human rights through their own actions. They must also not facilitate or contribute to human rights abuses by third parties, such as suppliers or business partners. If their operations have negative impacts on human rights, they need to address those issues promptly. The foundation for these responsibilities comes from the United Nations Guiding Principles on Business and Human Rights. While traditional human rights law mainly focuses on the obligations of states, these principles clarify that corporations have their own responsibilities. This includes avoiding direct violations and taking steps to prevent and mitigate any adverse impacts. The scope of human rights that corporations are expected to respect includes rights outlined in key international documents like the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. This covers a wide range of rights, including labor rights, non-discrimination, and protection against forced and child labor. When corporations operate in conflict zones, they also need to respect international humanitarian law. This means they should not engage in activities that could lead to war crimes, such as supporting illegal settlements. If they are complicit in such violations, company directors and managers could face criminal liability. From a law school perspective, understanding these corporate responsibilities involves recognizing the horizontal nature of these obligations. Unlike traditional human rights law, which is state-to-individual, corporate responsibilities govern business-to-individual relationships. The United Nations Guiding Principles have been key in clarifying corporate duties in the absence of binding international treaties. In practical terms, corporations are expected to implement due diligence processes. This means they should identify, prevent, and address human rights risks in their operations and supply chains. Conducting impact assessments and engaging with affected stakeholders are essential steps. If violations occur, they must provide or cooperate in remediation. While international law does not currently impose direct binding human rights obligations on corporations like it does on states, there is ongoing debate in legal circles about the potential for direct corporate responsibility under international law. Some experts advocate for international treaties that would clearly define corporate responsibilities and enforcement mechanisms. In summary, corporations have a recognized international responsibility to respect human rights. They must avoid causing harm, prevent abuses, and address any negative impacts related to their activities. This responsibility is grounded in international frameworks like the United Nations Guiding Principles and covers a broad range of rights. Law students studying this area should focus on the evolving nature of corporate duties, the differences between state and corporate obligations, and the practical mechanisms for corporate human rights due diligence and accountability.